is that donative intent, I mean, in theory, all three elements, donative intent, delivery, and acceptance, all three elements are of equal weight. But in my estimation, and you read all of the cases, or read as many of them as we're going to consider at least, you come to the clear conviction that of the three elements, donative intent is probably going to be determinative. That's where you as counsel for the alleged donee are going to work your hardest. Convince the court that by sustaining the gift you'll effectuate the intention of the alleged donor, and the rest of the job, the court will find ways to help you out. That's not invariably true, but it's true enough, as these cases indicate. And then we cover the so-called requirement of acceptance. Up until now, we have been thinking about the three elements, and noticed that the party who is alleging the existence of the gift has the burden of establishing each element by a preponderance of the evidence. More likely than not that there was a sufficiently clear expression of donative intent. More likely than not that there was either delivery or some recognized substitute for delivery. More likely than not, the intended donee accepted the intended gift. This third so-called element, as it turns out, is assumed by the courts. Upon closer inspection, there are really only two elements: donative intent and delivery or some substitute. If the subject matter of the alleged gift is of a beneficial nature, the law assumes or presumes acceptance. Even if for some reason the donee is unaware of the donor's generosity, of the donor's donative intent and delivery, for example, to a third person. You can't accept something unless you're aware of it, but the law erects the assumption or the presumption that if the subject matter of the alleged gift is beneficial, people accept gifts. There's an assumption of acceptance. Therefore, non-acceptance, and here let me give you all the synonyms. Non-acceptance, rejection, renunciation, repudiation. Those are all synonyms. Is an affirmative defense. The party, or not necessarily defense, it's an affirmative basis for invalidating the alleged gift. The party who is resisting the claim of gift has the burden of proving non-acceptance, of rebutting the presumption of acceptance. Oh, and it happens enough, certainly on exams. If there is anything in the facts that would suggest that the intended donee does not want the gift, make the argument that that constitutes a non-acceptance. For example, in Newell versus National Bank, Frank Newell was insisting that Emory take the ring back. As counsel for the National Bank, I would have at least made the argument that Newell's conduct in thrusting the ring back into Emory's possession indicates that Newell didn't want the ring. He was repudiating, renouncing, rejecting, and non-accepting the intended gift. If a person makes a gift, I mean, this is the easy situation. Somebody makes a gift of a bag of garbage to you. The nature of the subject matter suggests that non-acceptance may be an appropriate conclusion. Thanks, but I don't want this garbage. It gets a little dicier, however, when you make a gift of something that to most people might be considered valuable, but to a particular intended donee, there are reasons to think that that donee wouldn't want the subject matter. Superstition of the donee: I'm going to give you a broken mirror that may have some value somehow, and the donee, being superstitious, doesn't want it. Here, General Grant, I'm going to give you, while the Confederacy is still in force, I'm going to give you these valuable Confederate notes. Money is beneficial, and during the Confederacy, at least, Confederate currency had some value. But General Grant, patriot that he was, might have said, I don't want Confederate money. That's almost, that would be treason, he might have said. So my point is, use the facts. If there's anything in the facts from which the party who's resisting the claim of gift might be able to argue that the alleged or intended donee did not want the gift, the burden is on the person resisting the claimed gift to establish by a preponderance of the evidence non-acceptance, repudiation, renunciation, rejection. So to summarize, you start with donative intent. That's where you do most of your work. It turns out that although delivery, if you read Irons versus Small Piece, you'd think, gosh, there's got to be physical delivery. You start seeing all kinds of permutations and exceptions with these problems we've had. Delivery, it turns out, is a pretty watery or diluted requirement. And acceptance, it turns out, is presumed. What I hope this convinces you of now for the umpteenth time is that donative intent is the one that's likely to take most of your analysis. Don't skip delivery. You'll have to analyze that as well. But if you win on donative intent, the court is likely to be predisposed to overcome any scruples it might otherwise have about delivery problems. And we have a further example of that in Grimes versus Home. Talk about a court that's willing to manipulate doctrine in order to sustain a gift that the court feels that the testator would have wanted sustained. Consider the facts of Grimes versus Home. Mr. Bagley, what's going on there, please?
Okay, plaintiff is granddaughter, Nellie. I believe the last name would be Grimes in this case.
Mm-hmm.
She's the donee, and
The alleged donee.
alleged donee. The appellant here is the bank. Back to the case is in August of 1867, Federal Vandenberg confined to bed in failing health, signed over 20 shares of the Bank of Commerce of New York to his favorite granddaughter, Nellie. In the same instrument, he appointed his granddaughter as his attorney and giving her powers to sell and transfer the said stock.
I'm tempted to ask, are we using the word attorney to mean a practitioner of law?
That was unclear to me. I assume attorney in fact.
Meaning what?
A representative.
All right, someone who was authorized to do with the stock as she chose. Just observe here that they're using the word attorney not in the technical sense. Otherwise, ask your folks, hey, would you appoint me an attorney? And I could avoid this under screening program in law school in the bar exam. So they're using the word attorney here, power of attorney, if you look that expression up, not in the technical sense of someone who has been admitted to practice law, but a person who is authorized to act on behalf of the person making the appointment, a person who is given a power to do with the stock whatever she chooses. What's an assignment, Mr. Beck?
It's a deed that usually grants over not intangible objects like land, in this case stocks.
All right. A making over of an interest in typically intangible items such as stock certificates or contract rights or debts or something of that nature. All right. What happened then?
After Mr. Vandenberg made the will out, he says here, kept it for a while.
Kept what for a while?
The deed, the instrument.
The written assignment.
Right.
Uh-huh.
He kept that for a while and then handed it to his wife.
Uh-huh. And what did he tell her to do?
He told his wife that he intended it for his granddaughter. And he says, if I die, don't give this to the executors. It isn't for them, but it is for Nellie. Give it to her herself.
Yes. What did he do with the stock certificate?
The stock certificate itself, my guess is...
Don't guess. What did the court say? In fact, what is one of the bases for the defendants resisting the claim of a gift?
That it wasn't transferred.
Good. Federal Vandenberg retained the stock certificate. He delivered the written deed of assignment to his wife. Told his wife to... Where did he tell his wife to put it?
He didn't indicate, as far as I say here.